Hello, I'm Brad Edwards. Thank you for streaming with us here on CBS News Chicago. Big news on a big law. A judge ruled parts of Illinois' Safety Act are unconstitutional just a few days before it was set to take effect. Adding to confusion here, it will now not go into effect in some counties, but it will go into effect in other counties. Let's give you a little breakdown. The Safety Act includes bail reform. That would eliminate cash bail, among other things. Basically, if you commit a crime, you don't have to pay to get out of jail while you await trial. Those against that argued it would violate the rights of victims of crime and infringe on the court's power. 64 states' attorneys across the state of Illinois filed a lawsuit challenging the Safety Act. That's 2/3 of the counties. Wednesday's ruling means parts of the Safety Act will now not go into effect in those 64 counties that were part of the lawsuit. But it can still go into effect for the other 37 counties in Illinois that didn't join the suit, including Cook County. In the ruling, the judge added that any changes to the Constitution should first be put to a public vote. A lot to break down here. Joining us now to help us break it down, what it all means, is retired judge, respected jurist, Dan Locallo. Judge, a lot of moving parts here. Thanks for joining us. First of all, where did you stand on the Safety Act prior, yay or nay? And where do you stand on this judge's decision?
I previously opposed the Safety Act for a number of reasons: violation of single subject, violation of the Victim Rights Amendment, the attempt by the legislature to amend the Constitution by legislative act, and separation of powers. And I agree with Judge Cunningham's decision. The problem with the decision is right now there is no injunction. There is a possibility that the victorious plaintiffs will seek to have an order signed by the judge putting an injunction into place, because, as you correctly stated, right now the ruling at this time only applies to the 64 plaintiffs or 64 counties. We have 102 counties, so the issue is what's going to happen at Cook, what's going to happen in Lake, who did not join in the suit.
I mean, this is an unprecedented conundrum?
Well, I would say so. I mean, we have an example in the past when the Safe Neighborhoods Act was found to be unconstitutional. The judge at that time issued an injunction, and the case went directly up to the Illinois Supreme Court, and they found that based upon the violation of the single subject rule, they said that this was a proper ruling because it did violate the single subject rule of the Illinois Constitution. Having said that, when a single subject ruling is made, that goes to the entire act. You can't just parse out certain provisions and say, oh, this is okay, but this part is not okay. So that's going to be there's going to have to be some effort by either the victorious plaintiffs in Kankakee to get an injunction. And if the judge does issue an injunction, then it would apply to statewide. Then it's up to the Attorney General's office, when the case goes up to the Illinois Supreme Court, to defend the law.
Single subject.
Yes.
Break that down for me.
Single subject. Our Illinois Constitution, unlike the federal Constitution, requires if you're going to pass a law, it must address a particular single subject, or if the provisions of the bill will address a single subject. In this Safety Act, you have legislative redistricting. You have cancellation of auto insurance. You have a prohibition against the state police from buying military surplus weapons. What that has to do with cash bail, I don't understand it. So if with a violation of single subject, the whole act is subject to attack.
Yeah, basically this has multiple topics in it, multiple arenas are covered. It's not just about the elimination of cash bail. So moving on here, Attorney General Kwame Raoul and Governor Pritzker said they plan to appeal the judge's ruling, as you said, directly to the Supreme Court. Do you think the Supreme Court takes up this case?
They would automatically have to once a statute is declared unconstitutional. It automatically goes to the Illinois Supreme Court, and they will definitely have to address it because obviously this ruling is going to affect all parts of Illinois, and nobody knows. At the present time, some counties will have to follow it. Some counties are going to say that this ruling should be followed. But one thing that has to be is the Illinois Supreme Court in the past has set up a procedure whereby if the constitutionality of a statute is at issue, that the Attorney General's office has to be contacted so they can weigh in at that particular court. So I don't believe a judge can, sua sponte, say, well, this statute is unconstitutional. By Supreme Court rule, they have to contact the Attorney General's office to allow them to weigh in.
The Supreme Court's 4-3 Democrats. This is a Democratic action, the Safety Act. So will this all be a moot point when the Democratic-controlled Supreme Court upholds, hypothetically, the Safety Act, or you see it being a toss-up?
Well, I don't look at the Supreme Court as Democrat, Republican. They're supposed to follow the law. There is a case, Johnson versus Edgar, which basically said a violation of the single subject rule, the whole act goes out, and then it has to go back to the legislature to try to address those matters. So as far as I'm concerned, if they follow the law, I think if they believe and that the Constitution is violated under a single subject and agree that there's a separation of powers issue, that there's a violation of the Victims' Rights Amendment, and if they acknowledge that the legislature has tried to amend the Constitution by legislative act, then under those circumstances, I believe that there's a term, stare decisis. I believe that they should follow the law. We have some great justices on the Illinois Supreme Court, and I don't believe that the fact that they're from a particular party means that they have to rule one way or the other because of what a party stands for.
Yeah, and I don't believe you're clairvoyant here, but you're definitely insightful. Do you expect this to be kicked back to the legislature for really a mandated reworking?
Well, what should happen, in my opinion, is that the judge in Kankakee should sign an order allowing for the injunction. Then it'll go up to the Illinois Supreme Court to allow both sides to present their positions. Under one scenario, if the Supreme Court says the Safety Act is unconstitutional, then that allows for the issues to go back to the legislature, and they can form laws that would be in position where it does not violate the Constitution. So they have to amend some of the provisions. Now, what I don't understand is when the legislature did this, you have to remember that at 4 o'clock in the morning, they introduced the bill in the Senate, and within an hour, it gets passed, and then they go to the House, they do the same thing. I don't understand why the legislature doesn't allow the voters to weigh in, because normally if you're going to amend the Illinois Constitution, the voters have a chance to address that. Recently, we had the collective bargaining issue voted upon by the voters. Pritzker's graduated income tax was voted down by the voters. The Victims' Rights Amendment was voted by the voters. So why the legislature thinks that they can't trust the public's intelligence, I don't understand that.
Is it also strange, I mean, Attorney General Kwame Raoul is the people's attorney, and 2/3 of states' attorneys said we don't want anything to do with the Safety Act. So how come he's arguing for it?
Okay, well, the Attorney General of the state of Illinois has an obligation to protect the legislative acts. So if there's a challenge to the constitutionality, the Attorney General, who's the chief law enforcement officer of the state of Illinois, is required to defend against attacks of the constitutionality of a statute. His personal feeling is not necessarily something that dictates what his position is. He has to, again, his obligation is to defend what the legislature has passed.
Okay. So this end of cash bail issue, is it really that black and white? Commit a crime and get out for free while you await trial? Isn't there some latitude there, or no?
Yes, there is latitude. I mean, it's not a black and white type of situation where there's no gray area. There's going to be certain crimes that by law, assuming the provisions of the Safety Act are in effect and they're constitutional, what would normally happen is that the state would have to petition for an individual to be detained, and judges would normally have discretion as to whether they would allow the person to be detained, or they would have the option to set conditions for this person. By way of example, home confinement, or be monitored by pretrial services. The present situation, judges have the power under the Safety Act as is right now. It would be required of the state to file a petition before an individual could be detained. Now, there were some changes made in the veto session, but the problem is that if in fact it violates a single subject provision of the Constitution, no matter what the legislature does, it doesn't affect the fact that single subject takes out the whole act. So the legislature would have to go back to the drawing board. But again, I said, why don't they let the voters decide?
Yeah, this is strange in so many ways. So, I mean, strange in so many ways. Let me run a hypothetical by you. You commit a crime in Cook County. They didn't join the suit, so you have a better chance to get out for free while you await trial. You commit a crime in Kankakee County. They did join the suit, so you have a better chance you'll have to pay to get out. That would seem to make Cook County a more opportune place for crime or for criminals, and some say it already is. What say you?
Well, in Cook County, if the Safety Act provisions were in effect like January 1st, unless the state filed that petition to detain the individual, then that individual would have to be released from custody. It still does not preclude a judge from setting conditions like home confinement, but the fear of victims who have already been traumatized once is that the individual who allegedly committed the act is back out on the street. And that's a problem, because to me, if you have a property crime, I don't have any problems with allowing a person to be released. When it comes to violent offenses and repeat offenders, I think that has to be taken into consideration, which I don't think the Safety Act did, because the Victims' Rights Amendment was not taken into consideration in weighing in on a judge's determination as to whether the person should be detained or not detained.
Is there any place where a similar act, a similar law is and works, quote unquote?
Well, one example that has been cited by the individuals who support this type of law is the state of New Jersey. But in the state of New Jersey, there was an amendment to the New Jersey Constitution. In Illinois, there has not been an attempt to amend the Constitution by way of allowing the voters to weigh in. Purportedly, the New Jersey Act has been well received and appears to be working based upon what the voters in New Jersey ruled. Now, one example where the initial liberalization of custody was put in effect in New York, I think there's a counter move right now because of the amount of crime that's occurring in New York. So let the voters decide.
Yeah, that seems to be your message. How do you see it playing out?
Well, I right now I think that the plaintiffs will be successful in getting Judge Cunningham to sign an injunction. It'll go up to the Illinois Supreme Court, and if the court agrees with Judge Cunningham's analysis, then it'll have to go back to the drawing board. And I think Judge Cunningham, I believe, I haven't been able to see his whole opinion. I believe he indicated it should go back to the voters to determine.
All right. Retired Judge Locallo, a lot to unpack there, is there not?
It's quite confusing because, people, when they look to judges' rulings, they want to be able to have it in a situation that it's clear, that they know what to follow. Because right now, absent an injunction, you're going to have maybe 64 counties operating one way and 14 counties operating another way. And again, you have to remember that for purposes of the Safety Act as is, the state's attorney has to be the one to petition to the court for the person to be detained. And the judge did not have any say in that. And that's one of the problems, because that's a separation of powers issue, because the legislature is trying to dictate as to what judges can or cannot consider.
Remarkable. And remarkable insight, Judge Locallo, retired judge, a jurist, and we appreciate your insight in sorting things out, and we will certainly be paying attention as there's a lot of moving parts here, and one would expect they move fairly quickly, right?
Well, I mean, if Judge Cunningham issues the injunction, it probably will be today or tomorrow. And then it goes up to the Illinois Supreme Court, and the manner in which the Illinois Supreme Court generally operates is obviously there will have to be memorandums of law, briefs sent to the Illinois Supreme Court, and then they'll have arguments, and they'll have to make a determination as to what the Safety Act, whether it survives or not. So, I mean, it's not, I mean, I don't think that the Illinois Supreme Court is just going to make a determination in 1 day or 2 days. It's going to take some time, but hopefully the injunction will be issued. So at least for purposes of January 1st, 2023, the law will be held in abeyance pending what our great Supreme Court decides.
Judge Locallo, we appreciate the insight. The Safety Act in limbo.
Very much.
Yeah, we appreciate you joining us. The Safety Act in limbo, it's a story we will continue to follow here on the stream. I'm Brad Edwards. Thank you for joining us. Now back to the stream.